Hi, my name is Clint Coons, and I want to talk to you a little bit about the recent decision in Florida that affects single-member limited liability companies. I don't know if you've read anything about it yet, or if you've heard people talk about creditor protections for LLCs have now been blown out of the water as a result of the Florida decision. Well, I can tell you this. I've researched it. I've read the case. I was up on this case about a year and a half ago when it was first argued in front of the Florida Supreme Court. And I can tell you, if you live in Florida, yes, you do have a concern if you've created a limited liability company there, and you're concerned that if you individually, not the LLC itself, but if you get sued individually, can a creditor take your interest from you? Now, Florida is not unlike a lot of states when it comes to their statute, which has to do with the charging order. That is where if a member is being sued by an outside creditor, the LLC statute typically states that the only remedy available to the creditor of the member is this charging order. For those of you who don't know what a charging order is, it's a special remedy that states that whenever the LLC takes or makes a distribution to a member, that distribution must go to the creditor of the member. Now, that was that issue in this particular case, was whether or not the plaintiff could go after and take the member's interest, because they knew that the charging order in and of itself was not going to provide any solution to the plaintiff's debt that they had against this member, this judgment. I mean, think about if you're in the plaintiff's shoes. If you have a judgment against an individual and he has an LLC interest, you know that he's not going to be distributing out any funds if those funds have to go to you. I mean, that's the beauty of the LLC, that when your assets are held inside of it, nobody can get after them if they sue you individually. Well, in Florida, they wanted to break this down. They wanted to take the member's interest from them, because if they did, then they could get into his limited liability company and then get after these millions of dollars he had squirreled away. Well, as it would be, Florida Supreme Court looked at the statute. Now, this is something I've always talked about, how important statutes are when it comes to asset protection. That is, the legislature, when they draft a law, they specify what protections are available to members in LLCs and limited partnerships and corporations. And that's why we tell people jurisdiction does matter when it comes to asset protection. In Florida, the statute provides that the charging order is a remedy available to creditors. Well, the courts looked at that and they said, if this is a remedy that's available to creditors, it doesn't mean that it's a sole and exclusive remedy that is available to creditors. So a creditor is free then to go after the member in the LLC and petition the court to actually take their interest from them. This is typically referred to as a foreclosure action. Some of you may have LLCs set up in California. If you've been to any of my workshops in the past, you've heard me talk about the problems with California LLCs, and that they offer a creditor of a member the ability to foreclose on that member's interest, that is, take it away from them. Well, in Florida, this is what happened in the Olmstead case, is that the Florida Supreme Court allowed the creditor to take the member's interest because they said the statute in Florida, that is the LLC statute that governs protections for members, did not provide the requisite language they were looking for in order to protect that member from a creditor. Now, if you have an LLC set up, I'm sure that you need to be sure of what your state's laws, how they deal with this issue. Nevada, Wyoming, Delaware, they have some great statutes right on point that state that the charging order is a sole and exclusive remedy that is available to creditors. In fact, what we've put up on our website is a whole list of states, and we've broken them down as to which states are good states when it comes to asset protection and which states are the ones you should stay away from. And again, I'm only referring to those issues that deal with you as a member in an LLC if you were being sued and a judgment is entered against you. The LLC itself, if it gets sued, if something happens on the inside, you always have protections there. But it's on the outside that we're really concerned here. So a lot of times we design strategies to protect people who have LLCs, for instance, in Florida now or in California, and they want to protect their interests. So if should anything happen to them and a judgment is levied against them individually, that they do have some protections and that somebody cannot take that interest from them. So if you have the opportunity and you're concerned about this particular issue, please give Anderson Business Advisors and Law Group a call at 800-706-4741, and we'll be sure to walk you through the different states and the different liability protections that are offered by them and structure a plan that'll help you keep more of what you earn. My name is Clint Coons, and I thank you for listening to this.